Welcome to Integral Talks, a podcast series brought to you by Integral Advisors, where we dive into the world of compliance, risk management, and due diligence, and provide you with expert insight and analysis to help you make more informed business decisions. Hello, and welcome to Integral Talks, a monthly podcast series by Integral Advisors that delivers fresh, smart, and engaging conversations with leaders and stakeholders in and around what seems to be the most thankless role in business today, and that is risk and compliance. My name is Alberto. I'm the CEO and founder of Integral Advisors, and today we're talking ESG. ESG is an acronym that refers to a set of environmental, social, and governance standards that companies and investors consider in business decisions. It's a concept that's been around for decades. It's been called corporate social responsibility, social impact investments, conscientious capitalism. It's also been called woke capitalism by opponents. Among those leading the efforts is Florida Governor Ron DeSantis, who on May 2nd signed into law House Bill 3, or HB 3, which blocks consideration of ESG factors in 5 key areas: investment of state money, investment of pension funds, issuance of bonds, government contracts, and banking. HB 3 makes it unsafe and unsound for banks to deny or cancel its services to a person or otherwise discriminate against that person on the basis of a person's political beliefs, religious beliefs, and other factors that are not quantitative, impartial, and risk-based. To help shed light on what all of this means for banks in Florida, we have invited not one, but 2 guests today. Carl Fornaris is a partner at the law firm of Winston and Strawn in their Miami office. Carl is co-chair of the firm's financial services practice and represents clients on licensing, transactions, acquisitions, regulatory compliance, and enforcement proceedings. Marina Olman-Pal is a shareholder at the law firm of Greenberg Traurig in their Miami office as well. Marina advises foreign and U.S. financial institutions on a broad range of regulatory matters, such as compliance with laws and regulations, licensing, acquisitions, and divestitures. Welcome.
Thanks, Alberto. Happy to be here.
Great to have you both. So let's just start. Give me a bit how you guys, in terms of this topic, ESG and this particular law, HB 3, what has been the focus of your practice just in the last couple of months?
So I'm happy to jump on that and get started. Carl, if you're okay with that. So we've been at GT advising financial institutions from money services businesses, banks chartered in Florida, nationally chartered banks as well, who are qualified public deposits and hold public deposits, in navigating House Bill 3, the requirements of House Bill 3. We've also been tracking it from the beginning since it was proposed earlier this year, and really been helping our clients try to get clarity as much as possible with respect to its requirements. What are sort of the compliance requirements imposed on our banking clients, and what sort of changes to policies and procedures may need to be done in order to comply with this new law.
Are pretty much along the same lines as Marina?
Yeah, similar as well. Representing a variety of depository institutions that are trying to figure out how burdensome this will be, particularly out-of-state institutions that act as qualified public depositories. So for those in the audience listening, a qualified public depository is basically a bank that has been pre-approved by the state of Florida to receive deposits of the state of Florida and its agencies and instrumentalities. So it's basically a trusted bank that provides banking services to the state of Florida and holds Florida public money. So they have certain burdens under Florida House Bill 3 that became effective 5 days ago, to be compliant and then to report annually and attest as to their going forward compliance. And so the question is how much, how heavy is the burden versus the compliance risk. And so it's that balancing act that is taking place, I think, amongst many public depository institutions that aren't necessarily banks that have offices in Florida, that are determining whether it's worthwhile to continue in light of the burden posed by the new law, which we're going to get into in detail.
So I wanted to ask you about defining a little bit more that qualified public depository, which you just did. But does that mean that do all banks in the state of Florida take state money? Are there banks in the state of Florida that do not and then would not qualify under this HB3? In general,
I think the short answer is that not every bank that has a brick and mortar operation in Florida is a qualified public depository.
Okay.
You have to go through an approval process.
Okay.
And so there's probably about 130 or so qualified public depositories. The state of Florida maintains a list that's accessible to the public. And by scrolling down the list, you'll see the names of the banks that are on there. It's mostly banks that have a physical presence here, but there's also banks that don't, that are some of the larger banks. And so they provide effectively cash management, investment management services to the state of Florida.
Okay. All right.
Yeah, and just to add a comment there. So there are banks that are operating in Florida that would not be subject to House Bill 3. And just one example, and I think Carl was describing it well, but one example is nationally chartered banks who don't act as a qualified public depository, for example, or out-of-state banks, right? Non-Florida chartered banks that have some presence in the state that do not accept qualified, or that are not qualified public deposits. They don't accept public funds or hold public funds. Okay. So, it's an analysis that needs to be done to see whether House Bill 3 would apply to the bank.
Yeah, that's Marina, that's a good point. That's a really important distinction. So if you're looking at this for the first time, right, does this apply at all, right, to the particular institution? And the decision tree, I think, goes in one of three ways. You're either a public depository, in which case you have to comply, or you're not a QPD, but you are a state licensed institution, in which case you have to comply, or you're not a QPD and you're not a state licensed institution, but like Marina said, you're a national bank that's not a QPD, that's not a state licensed institution, in which case you don't have the burden at all. The second path, which is that you're a Florida institution, that can be one of many types of institutions. And Marina, maybe you could describe what the types of institutions are that would be picked up as state licensees.
Sure. So it's state chartered banks, foreign banks that have some sort of presence in Florida. International branches, agencies, rep offices, admin offices of foreign banks, money services businesses, consumer lending companies. I think it's state chartered trust companies as well. Just off the top of my head, am I missing anything, Carl?
And maybe maybe state licensed credit unions.
Credit unions. Right.
Yeah, so that's a pretty big bucket, Alberto, of Florida licensed institutions. So not just the depositories, but also the state licensed MSBs.
Right.
That's right.
Pretty much any large MSB is going to have a state license, a Florida license. So they're gonna get picked up by this, and then any consumer lender that is licensed under Chapter 516 would also be picked up by this.
So HB3, and just researching for this podcast, I came across many articles. Anti-ESG bill. It's been called one of the furthest reaching efforts against ESG. What separates this particular law from laws that we're seeing in other states? I think there might be about 20 different states that have some sort of anti-ESG directive, but Florida seems, at least it's getting a lot of press, that it seems to be one of the most aggressive so far. What makes Florida different than some of these other states? If you can comment on that.
Yeah, I mean, Alberto, what we've seen is the number of ESG initiatives, state ESG initiatives. There's a number of them. I think it's probably even more than 20.
Okay.
There's legislative proposals being considered. There's regulatory guidance, proposed regulatory guidance at the state level. Of course, we have that at the federal level as well, considering ESG initiatives, either pro-ESG, anti-ESG. So it varies widely. In terms of the anti-ESG initiatives, I know there's at least like 19 states or so that have, there's a letter that they've recently signed. I think it's in March of this year. It's a list of 19 states that have agreed to essentially lead state efforts to ensure that state public funds are not invested in ways that would consider ESG factors. It's a list of 19 states, and Florida is actually one of those states, and Governor DeSantis did sign it. So a lot of the states that are looking at anti-ESG initiatives are really focusing more on the investment of public funds and just making sure that those investments are not considering ESG factors, but more, pecuniary factors, return on investment, et cetera, but that don't have a requirement to consider an ESG factor. With respect to House Bill 3, what we have and has passed, obviously, is much broader, right? It affects, as we were just mentioning before, banking institutions. It affects money services businesses, consumer lending companies, et cetera, requiring them to make sure that they're not engaging in unsafe and unsound practices by discriminating or considering factors that are essentially the protected factors. So it's much broader, and it applies to a broader number of financial institutions than the other states. But what we've seen, at least I don't know, Carl, if you've seen something else, but what we've seen so far is really most of the other states are really focusing more on the investment of public funds in terms of anti-ESG.
Right.
Yeah. There's also, go ahead.
No, I think that's right. And in Florida, I think I commented earlier that there's about 125 QPDs. So as of May 2023, Florida had 118 QPDs. So I was a little bit off. And of those 118 QPDs, 23 of the 28 federally chartered banks that operate in Florida are QPDs. So there's 5 federally licensed banks and trust companies. So think of national banks that are not QPDs and necessarily are not Florida licensees. So they avoid all of this completely. They don't have to comply with the restrictions and prohibitions of House Bill 3. But you're going to have 23 nationally chartered banks that are going to have to comply with that are QPDs that'll have to comply with HB3 and the so-called anti-ESG provisions. So look, I think what's going on is we're at a time in our country's history where there's a lot of divisiveness politically on both sides of the aisle, and it's become a Cold War of sorts between conservative state legislatures and federal policymakers. Right. Under the current administration in Washington, and so you're now seeing state legislatures, wading into matters that have always been handled by federal regulators. And I know we're going to get into this with HB3, but HB3 makes it an unsafe or unsound banking practice,
right,
quote unquote, unsafe or unsound banking practice for a QPD or a Florida licensed depository institution to engage in ESG practices as defined under the statute, which we're going to get into.
right.
But that's just something that a state would never have gotten into. Or similarly, with Florida passed at the same time as HB3, the restrictions on companies and individuals and interests of the Chinese Communist Party acquiring interests in land directly or indirectly, whether it's a residential property or a shopping center or an agricultural property. You would never have seen a state get into excluding certain businesses or individuals based on nationality, and so that I think is a sign of the times that we're in right now.
Yeah. And I just want to raise, Alberto, if you don't mind, just a quick point on the state initiatives, because it has a true potential to become a huge headache for banks, primarily operating in the U.S. There are some states, as we were mentioning, that are pro-ESG and have pro-ESG legislation that they are currently considering. I can tell you California, for one, is one that has proposed legislation, pro-ESG legislation, that would run counter to House Bill 3. It's a little bit different, but it essentially requires that California state agencies not work with banks or lenders that have customers that manufacture firearms. Mm-hmm. And that's one of the protected activities under House Bill 3. So it's completely inconsistent. And then, for example, New York, has similar pro-ESG legislation that they're considering, and also the DFS has proposed guidance, pro-ESG guidance, that would require, the banks that they regulate to take into consideration environmental factors in conducting their risk analysis and looking at the risk profile of the bank. And so there's going to come a point where, if all of this passes, these banks are going to have to figure out how to comply with state ESG and anti-ESG laws that apply to them, and how to, try to make sure, again, like, they're compliant, and then when there's just so much inconsistency too. So I think it's very problematic. It's something that's definitely raising concerns in the industry. Mm-hmm. And we'll see how it gets resolved. I know we've had some discussions here in Florida as to whether, there's been, and we had mentioned it, some QPDs that are considering, should we withdraw from Florida as a QPD and then just offer other services so we're not subject to House Bill 3? If we maintain a state charter, should we switch to a national charter? So there's been a number of considerations and strategies that are being taken into account to see how we, our banks, will comply with this.
Well, that's a great point. I'm glad you brought this up, because one of the things that I wanted to ask you both about was really we all live in Florida. We're in South Florida. Everybody seems to want to be in South Florida. There's capital coming. There is investors coming this way, and it continues to grow. This is one of the hottest areas in the world, I would say. And so you have, for example, European banks. So in the EU has ESG as part of legislation. They've got something, I think, called the Corporate Sustainability Reporting Directive that is going to be requiring certain reporting of data on ESG initiatives, that if you don't comply with that as a European bank, you will likely be banned from operating in Europe. So I know let's talk hypotheticals, but how, what do you say to a foreign bank that is considering or has that issue, right? They have, the EU is their own regulators at home are saying you have to have ESG reporting data. And then, so, tell me a little bit about that scenario, and what would you advise a foreign bank that's coming from Europe into the States, into Florida, I should say?
That's a great question, Alberto. And we've had that issue come up in terms of, just like you stated, right? Interest in the state by a foreign bank that's regulated by the European Central Bank, subject to ESG requirements of the European Central Bank. And the question is, how do I comply with House Bill 3 in a way that would not be problematic with the framework that I'm operating under? And it's a true concern. It's a true concern. It just, if you're going to establish, a rep office, admin office, as we were discussing before, you're going to be subject to House Bill 3.
Right.
So I think it's a matter of, looking at, again, policies, procedures, seeing what sort of controls you need to have in place locally for your operation in Florida, and then seeing how you can make that work within the larger framework that you're operating under.
Okay.
Carl, if you have other thoughts.
Or you want to?
No, I agree. I think it's important that whatever you have, if you're a non-U.S. institution, in terms of policies, procedures on the onboarding of clients, that there should not be anything that provides mandates as to not providing services to a group of customers in the United States because they don't check off certain boxes, which we'll be getting into.
Right. So let's get into the what Carl mentioned earlier, the attestation requirement that went into effect July 1st. Is that right?
That's right.
Okay. So effective July 1, banks had to attest to what? And then talk a little bit about, I think this is an annual attestation, and then just in general, what are the penalties for non-compliance of, with this, with HB3?
So I'm happy to get started on that. And then I guess, Carl, I'll push it to you on the penalties for non-compliance, if that's okay.
Sure.
So the OFR has published proposed attestation language for Chapter 655 regulated entities, for 560, so the MSBs, et cetera, for all the institutions that it regulates that are subject to House Bill 3 and need to attest. That attestation that needs to be filed with the OFR for the banks the first attestation is due or was due July 1st. Part of the issue with this law is that it passed so quickly and it became effective so quickly that the attestation forms were not finalized in time. So we don't have like a final form of an attestation that needs to be submitted. And so everything has been in proposed form. So a lot of the banking institutions, all of the banking institutions subject to oversight by the OFR received an email or should have received an email from Jeremy Smith, essentially giving them proposed language for the attestation that they needed to file by July 1st. So all of those institutions should have filed some form of attestation. There isn't, again, a set final form yet. That form should be finalized, we think, at some point in August is the information that we're getting so far, but they should have attested. That attestation should have stated something along the lines of, we attest as a financial institution that we are in compliance with the new subsections of 655 that were added to reflect House Bill 3. And then that attestation also provides that it needs to be signed by an authorized officer. It needs to be attested under penalty of perjury. So that's the OFR form. FIBA has submitted comments on the form that the OFR has published. There's two specific concerns that we raised, primarily looking at the QPD form, which is very different. So the QPD form is an attestation form that is being made by the financial institution, so by the QPD, under penalty of perjury, and is signed by an authorized officer of the QPD, to the best of their knowledge, the QPD is in compliance with House Bill 3. The OFR proposed form instead is a form that is an attestation form that is signed by an authorized officer. It's an attestation of an authorized officer that the financial institution which that authorized officer represents is in compliance with House Bill 3. So there's a big difference there. There's number one, the knowledge qualifier, and then just the structure overall as to who's actually making that attestation. And so the comments that we submitted to the OFR that are currently being considered, and we're waiting on a response, is to have the OFR form reflect or more closely reflect the QPD form, which is, right. And it's also consistent with House Bill 3, which is that the financial institution would actually attest to its own compliance with House Bill 3. Of course, signed by an officer. Yes.
Let me just define a couple of terms for listeners. So OFR, because there are some people that are listening to this outside of Florida, is the Office of Financial Regulation, which is a state regulatory agency. And Marina mentioned FIBA. FIBA is the Financial and International Business Association, formerly known as the Florida International Bankers Association. So I want to make sure that listeners know what those acronyms stand for.
Thank you, Alberto.
We're so used to just,
so,
we're off from Miami.
No, so. We talk locally. Yeah. No, absolutely. So, I mean, that's sort of what that looks like. The MSBs also have their own attestation form. And again, it's, they're all due at different points. So the OFR regulated entities have to attest every July 1st. Mm-hmm. QPDs that have been QPDs before July 1st have to attest when their annual report is due, which is November 30th. Right. If you're applying to qualify as a QPD between July 1st and November 30th, then you're supposed to be doing it at the time that you're applying for qualification as a QPD. And money services businesses would need to file at renewal of their licenses.
So before we get into the penalties for non-compliance, let's dig a little bit into this and what banks have been doing or have to have done, as far as attesting to compliance with HB3. So we know, all of us know that banks in the past have had in their policies prohibited customer types, prohibited customer lists. I was looking at one yesterday of an actual client of ours who, 5 years ago, had as part of their policy, dealing in the sale or distribution of arms was a prohibited customer type. So our banks, it seems like banks have been or are required to go back and basically scrub their policy of that type of language and those types of, review their prohibited customer list. Like what have banks had to do up through July 1 and going forward to be able to comply with this attestation requirement?
Well, I'll jump on that question. Yep. I think there is no prohibition on past decision-making with respect to customers that were cut loose, whether it was for an ESG reason or non-ESG reason.
Right.
So the past is a past. Obviously, from July 1st going forward, that's where the compliance risk comes in if you're a Florida QPD or you're a Florida licensed financial institution. But in terms of the past, I think there's nothing in the statute that says anything about policies or procedures. The practical problem is that if an institution does have policies and procedures or some type of written statement regarding, let's call it ESG principles or something else similar to that. Mm-hmm. And that is still in the institution's files. The question then becomes after July 1st, because a scrub wasn't done, because a review was not completed, is whether a attestation can be found to be quote unquote materially false, because in fact, the institution still has procedures regarding particular customer types. And so let's talk a bit about customer types, because this is at the root of House Bill 3. And what I think what state regulators would say is that to call HB3 an anti-ESG bill is a bit of a misnomer. Mm-hmm. Although perhaps certain sectors in the state might take the view that is the case. But I think what the financial services regulators would say is that this is fundamentally an anti-de-risking law, an anti-de-risking law. So let's step into a time machine and go back 8 or 9 years ago or so. And back in 2015, the Financial Action Task Force in Paris put out a statement, which was groundbreaking at the time, that basically said that institutions worldwide should not engage in quote unquote de-risking. And so, what is de-risking? De-risking is when an institution decides to terminate a relationship, not because the relationship in and of itself is the problem or creating risk, but because the relationship is part of an entire class of customer, a customer type. For example, money services businesses.
Mm-hmm.
So in the time between approximately 2003, 2004 or so, up to 2020, leading up to 2015, when the FATF put out the statement, MSBs, just because they were MSBs, were finding their accounts getting terminated, without any explanation other than any bank saying, "Look, you're an MSB. We're just gonna close up your account because for us it presents too much risk." And so when you parse the language in HB3, and while there is a lot of language in there that says that an institution cannot condition the provision of banking services on the basis of a customer's political opinion, speech, affiliations, a customer's religious beliefs, a customer's social credit score, or other social factors, that is at the heart of de-risking, or in the case of HB3, anti-de-risking. So what HB3 is telling institutions that want to comply is that you cannot deny or cancel the provision of services because of these immutable characteristics, right? And instead, the decision to onboard a client or to maintain a client relationship has to be based on an impartial, quantitative, and risk-based approach, case by case. So if a customer is an MSB and the customer is being thrown out just because they're an MSB, that would be problematic under HB3. The institution instead would have to make a case-by-case determination as to that particular MSB, that the decision to deny services was based on a quantitative, impartial, and risk-based standards.
So can you elaborate on that part, that quantitative? What exactly do banks need to quantify?
Yeah, and the statute doesn't say anything beyond quantitative, impartial, and risk-based standard. Mm-hmm. So it leaves it up to the bank to figure that out. Okay. But I think what's behind that is that I think when you think quantitative, you think numbers, you think financials, you think numerical data. And so I think that would be one factor that would have to be taken into consideration, whether the decision to deny services is appropriate because there would be too much of a cost, for example.
Let me ask you, I'm going to throw a little curveball. So if a bank that has public shares and shareholders, they determine that by doing business with certain customer types will hurt their brand, and they potentially feel that shares will be sold and it impacts the share price. Is that something that the bank can utilize to quantify that there is a risk, financial risk? I mean, I know it gets a little tricky, but it's not just, I guess you're saying on a case-by-case basis or on a client-by-client basis. That makes
right.
a lot more sense.
On a client-by-client
basis. Right.
Right. And that goes back to the FATF de-risking statement from 2015. And even more recently in 2022, the federal banking agencies published a joint statement on a risk-based approach to assessing customer relationships and conducting customer due diligence, and the whole concept of quote unquote de-risking. And in that joint statement, the agencies reinforced their position that no customer type presents a single level of uniform risk or a particular risk profile related to money laundering. And that the agencies are not directing banks to open, close, or maintain specific accounts, and that the agencies do not want to see banks declining the provision of banking services to an entire category of customers, the MSP example.
Right.
You can take that to other categories of customer types. And so you can't throw the baby out with the bathwater. It is basically what the federal agencies there have put out in their joint statement, which tracks what the Financial Action Task Force has done. Now you take it to HB3, and HB3, I think what the Florida regulators would say is that you're basically tacking on HB3 to what the federal anti-de-risking statement provides. Now, HB3 takes it to a completely different level, as Marina was saying, because of the attestation requirement, which is submitted under penalty of perjury.
And I'll just add there, Alberto, and one of the things that we've been hearing, or concerns that we've been hearing the most from our banking clients and our MSB clients is this, what we call the three-pronged test: the quantitative, impartial, and risk-based. Banks, MSBs, when they're making their onboarding decisions. And by the way, it's not just whether we're going to offer or deny services, but it's also discriminating against customers. So I'll get into that in a little bit, but it's a little bit broader than prohibited customers. You have to take a broader view of this, but it's that quantitative, risk-based, impartial. So risk-based, impartial, these are decisions that banks are used to making and analyses that they're used to implementing on a day-to-day basis. The issue that has come up is the fact that, there's a reference to this quantitative analysis. And the question is, what does that mean? And the fact that the three-pronged test has an and instead of an or in between all three, which means that you have to make your analysis or do your analysis, in satisfaction of those three prongs. And so with respect to quantitative, I fully agree with Carl in terms of the analysis. I know we've had some conversations with the OFR, and there's been some indication that quantitative does, reflect the number analysis, a cost analysis. Do I have the resources in place to mitigate the risk that this client presents? And then there could be other, quantitative factors that you could consider. But I think the take-home point for financial institutions that are subject to House Bill 3 is to make sure that starting July 1st, their policies and procedures reflect that there's been that quantitative, risk-based, and impartial analysis as to why you would deny services to a particular customer, or as to why you may require additional information, such as enhanced due diligence from a particular customer. So, for example, there's some customers, that present heightened risk from the AML perspective, cannabis businesses, MSBs, you may require additional due diligence, enhanced due diligence from those customers prior to onboarding them, throughout the relationship as well. If you are going to require additional due diligence, you're going to want to document why, What's the risk analysis that you've conducted on that customer? Why are you requiring additional due diligence? And just to make sure that it's not going to be an analysis that may be viewed as discriminating against a particular category of businesses or industries, and that it properly documents compliance with House Bill 3. And same thing when you're denying or terminating a relationship. Sorry, go ahead.
And I'm sorry, just let me jump in and say that so this is only in the case where you are, you have made a decision as a bank to deny or terminate a relationship. You don't have to quantify in the other direction, which is if you do open the account for right? That's not required. If you do open an account for a gun manufacturer, you don't have to document why. You have to do that quantifying analysis on a previously prohibited customer type, and then you open the account. Do you have to document that, or you only document it in the case where you've decided because you have the metrics to demonstrate to the OFR that you are going to deny this account? I'm just trying to understand.
Well, the statute doesn't require a documentation for denial or cancellation.
Okay.
Of services.
Okay.
But I think you are, as an institution, you are creating your own risk trap if you don't document the denial decision.
Right.
And because how can you prove to an inquiring regulator, or if you're a QPD, to the chief financial officer's office or the Florida AG's office, and we'll get into that in a bit. How can you prove to them that the denial or cancellation was not on a quantitative, impartial, and risk-based basis? And so I think that's where the best practice is to have some type of process. And in fact, we were talking earlier about doing a scrub to make sure that you don't have anything that affirmatively states we're not going to bank MSBs anymore. But to take it a step further, which is to have a process that says when we're going to reject any customer that's in Florida, or I should say it could be a customer anywhere, but for a bank that has to comply with HB3, that we're actually going to have a process every time where there's a denial or cancellation to, in a one-page file memo, whatever it is, just to have some backup that the decision was based on a review of quantitative, impartial, and risk-based standards. So for example, the hypothetical that Marina raised, a cannabis business. Okay, I think it's a problem to say that. Well, not necessarily. That poses a question. What if you have a policy that says, well, we're not going to bank any cannabis businesses at all? Well, that is on a risk-based basis. That's probably okay, because under federal law, marijuana is still a Schedule I narcotic, which makes it a felony to be engaged in that business.
Right.
So you would probably satisfy that. Is it impartial? It is impartial because you're complying with federal law. Is it quantitative? Well, it's probably going to be extremely expensive to the institution if a federal prosecutor ever wanted to conduct a review, an investigation, bring charges, whatever. As a theoretical matter, that's the risk. As a practical matter, it's probably non-existent. But I think that would be one approach with that type of a customer type. But what if it's a customer from a high-risk jurisdiction, like not necessarily Cuba, because Cuba there's an embargo. Right. OFAC has very strict rules. But what if Venezuela, where there isn't an embargo, you can still provide services legally to almost all Venezuelan institutions, because there aren't sweeping OFAC sanctions programs against Venezuelan interests. So could you turn down all Venezuelan customers? Under this standard, I don't think you could. That would be a problem, because it wouldn't be impartial and it wouldn't necessarily be risk-based. Now, when you go through the analysis, it could be, as Marina said, it could be too expensive to comply. Right. And therefore, you couldn't provide services to that particular Venezuelan customer. But the question is to do a sweeping we shall not provide services to Venezuelan customers. That's the question. That's the compliance challenge that HB3 poses.
Yeah, and I think that's a good segue into penalties for noncompliance. When you are we talked about documenting that it's not required to document, but it's a best practice. I think it goes beyond now best practice, which is because there is a component in HB3 that allows for someone who's been denied service to file a lawsuit against a financial institution. I would imagine a financial institution would want to properly document that denial and that support. Can you talk a little bit about that component of HB3 and why that's a bit of a game changer?
Yeah, certainly for QPDs, Marina mentioned the attestation requirement. So every year, a QPD, there's 113 of them. They're going to be submitting these attestation requirements to the chief financial officer. If the chief financial officer determines that the attestation form is quote unquote materially false, the chief financial officer of the state of Florida must report the finding to the Florida Attorney General's office. And then the Florida Attorney General's office may bring a civil or administrative action against the QPD for damages, injunctive relief, et cetera. So CFO, if they determine that it's materially false, hypothetical, customer writes a letter to the CFO's office, customer manufactures guns, says, I was denied services. And the CFO's office gets that letter. They start looking, they look at the attestation, they start asking questions. And by the way, on the attestation form, the bank, that's QPD, is making a promise to provide documents to the CFO's office if the CFO's office requests them to determine compliance with the reporting form. And so if the CFO's office has said, you know what, yep, it was a gun manufacturer, it was denied services. And then the question is, well, was it denied services because of that particular customer, or was it denied services because they were a gun manufacturer and the bank takes an anti-gun stance, for example? The CFO has to report the finding to the AG's office, and then the AG's office may bring a civil lawsuit or administrative action for damages against the QPD or a cease and desist. The CFO can also, this doesn't have to go to the AG, they can suspend or disqualify a QPD for failure to file the attestation. Or if the QPD no longer meets the definition of a QPD because it doesn't meet the standards under House Bill 3. And then you go into a suspension period that isn't longer than 6 months. And then if a QPD is disqualified, they can't reapply to become a QPD again after 1 year waiting period. So, but by that point, that bank probably will not want to be a QPD again after the bad experience that they had with the state of Florida. In terms of some monetary penalties, I've mentioned administrative penalties against QPDs. The CFO can impose a penalty not to exceed $1,000 for each violation for any that is knowing and willful. And so each day constitutes a violation, a separate violation. And then a failure to timely file the attestation is going to be deemed to be a knowing and willful violation. And then, of course, I think I mentioned a cease and desist order can also be imposed. So there's a lot of bite behind this that the CFO's office has with respect to QPDs. With respect to Florida licensed institutions, remember that HB3 says that if you're engaging in, depending on your point of view, ESG practices or de-risking practices, that can be found to be that is under the statute a quote unquote unsafe and unsound banking practice. That then becomes a violation of Florida banking law. And the state of Florida bank regulators have a variety of enforcement tools at their disposal, including civil money penalties, cease and desist, et cetera. So there's plenty of reason for institutions to take House Bill 3 seriously.
Yep. We are actually running out of time, but so I want to ask a couple more questions, maybe 3 more. But just I think we have about 10 minutes. But let's talk just kind of high level on the impact on AML, CFT, compliance programs. How does HB3, what's the biggest impact that it will have on compliance programs? Does it impact, for example, risk rating methodologies on certain types of clients? Does it impact anything related to politically exposed persons and those customer types? So just kind of maybe Marina can take this one, just in general, what are the big AML, CFT compliance issues related to HB3?
I mean, BSA, AML, CFT compliance requirements remain the same. They're federal. You still need to comply. Nothing changes in terms of the analysis at all.
Right.
I think what becomes most important is what we were discussing earlier, which is, well, there are some analyses that are more qualitative analyses, such as Carl's example of a Venezuelan customer, for example, and the type of risk that the customer presents.
Mm-hmm.
And if you decide to deny services to a customer that's in a protected category by House Bill 3, or if you decide to treat that customer differently, such as the example that I was giving before, which is, for example, requiring enhanced due diligence, I think best practices is just making sure that that analysis for the different treatment or the denial should be properly documented to ensure that it's in compliance with House Bill 3, to ensure that it reflects that you've gone through the quantitative, impartial, risk-based analysis, and that based on that analysis, the bank has made a determination, the financial institution has made a determination to either deny, terminate, or require additional diligence. But I think it's just an analysis that needs to be done, and it needs to be accurately reflected as well. One of the concerns that we have been hearing with respect to BSA, AML compliance, and House Bill 3 is that there are times, right, that financial institutions have to file suspicious activity reports, right? Those SARs, right, to report to FinCEN activity that the financial institution has identified as suspicious for money laundering, illicit, etc. Those suspicious activity reports, short for SARs, are confidential and cannot be disclosed, right, to the public, etc. So one of the concerns of the industry is, well, if we have a client, a customer that we terminate, and we terminate because that customer presents too much AML risk that we don't have the appetite for, and let's say we filed already 3 SARs on this customer, and our procedure is, look, after 3, we terminate the relationship, then, how do we document that, right? Or we document it, but what if, there's a complaint later on, from a customer, how do we deal with that? Because this is confidential information that we cannot disclose or share. And so there are some concerns with respect to complying with House Bill 3 and also complying with BSA, AML requirements that the industry has raised, which I think is a great point. I think there's a lot of guidance that I'm hoping one day we will get from the OFR, from the DFS with respect to House Bill 3 and the expectations on financial institutions that are impacted by House Bill 3. Hopefully at some point it'll be written guidance that will really help, set the parameters for what needs to be done and what's expected. Maybe we'll get that through examinations, right? As the law is now in effect, and we start having examiners come into banks and review policy and procedures. Maybe we'll get the guidance there. But I think it's something that, needs to happen hopefully sooner rather than later.
Okay. All right. Well, that's great, actually, and that overlapped a little bit into my next question, but I think you addressed it. That's a very good example of the SAR issue. So I want to just kind of finish on a lighter note and get off topic a little bit. We've done this in previous podcasts and a little bit of a curveball, but so I am a very avid fan of music. I go to concerts. I listen to, I have a big collection of music at home. I've taught my kids all about rock music and all different types of genres. So I wanted to pose a question to you guys. This is the first time we have two people as guests on the podcast. So do you have a favorite duo or a favorite duet that you've listened to in the past, and any duo? And I'll give you an example, like a Hall & Oates, right? A duo, a pop, band. Is there anything that any song or any duo that you can think of, or duet that you can share with the audience? So I don't know, whoever wants to take that off-topic question.
I'll go first. That's an easy one for me.
Good.
Easy Lover by Phil Collins and Philip Bailey.
Wow. That's kind of obscure, but yeah, a big hit back in the 80s.
Big hit.
Marina?
Phil Collins is great. You know that you caught me off guard, Alberto. I have no idea. I can't think of.
Think of the classic,
like a lot of groups.
Like Sonny and Cher. Think of some of the classic.
Sonny and Cher is good.
Yeah, there's so many great ones. I'm going to say my favorite is Stevie Nicks and Tom Petty. Stop Dragging Your Heart. Carl, you know that song?
Of course, for sure.
One of the great duets, in my opinion, of all time. So
I didn't know you were such a big music fan, but I was watching yesterday. The president of Ukraine, Volodymyr Zelensky, was being interviewed, and he said the way he tries to de-stress is he listens to AC/DC.
Oh, good for him. I could see that.
Can you imagine that? That's a de-stressor.
Yeah. Well, my oldest son, who plays guitar, and AC/DC is one of his favorite bands. So I've heard Thunderstruck so many times over the years, just from trying to learn it. So anyway, that wraps up our podcast today. Thank you both to Marina and Carl for your time. Again, this is Integral Talks, and stay tuned for the next podcast.
Alberto, thank you for having us.
Thanks a lot.